Regardless resident status abroad, living outside the shores of one's homeland can really be challenging and sometimes very difficult. Let's be sincere, to keep pace with applicants from the host country abroad can really be difficult. Here on Dialogue in Diaspora, we give you every information, every news, every current issue you need to know on applicants outside the UK. Dialogue in Diaspora is your link between the world and the United Kingdom. It's your window to African development. Here, live on Ben Television. Thank you for joining us this day as we present to you another episode of Voice here from Ben Television. On the program, we'll take a look at legal matters in the United Kingdom, issues that may affect you as you live in the UK from whichever angle, either as a student or as a settled member of the community, or you're trying to regularize your stay, or you're even in business, or even if it concerns housing matter, or even issues around your children, social welfare. These are some of the issues that we take a look at from a legal perspective here on the show. And it is Voice, your legal community program. We've been on for some time now, and today our guest, as usual, we've given her a title legal community champion, Jennifer Obaseki. She's won a lot of laurels for her contributions to community development and programs as well. I present to you Jennifer Obaseki, the senior partner at Obaseki Solicitors, our guest of the program. Jennifer, thank you for coming on the show again. Talking about people who are vulnerable, I mean, we've heard lately this development of people who have been in the UK for some time, and the Home Office asking them to go back home, deporting them. We've heard stories of grandmas
being detained,
elderly people who have been in the UK since 1970s, but for some reasons they have been asked to prove their status, and they haven't got that. Let's take a look at what. I don't know if any of our viewers will be in that situation, but there are circumstances where people have been here a long time, long residency, and when things are down, they will find it difficult to prove their status.
Yes. Most importantly, people need to be aware that even if you're here beyond 30 years, 40 years, and in one of the cases, I think it was almost 56 years, you can still be asked to prove your right to be in the United Kingdom. The cases that we're talking about, you're referring to, there was a grandmother who has a British daughter, British grandchild, been here for over 40 years. She was in detention. She was detained for a number of weeks. And that's despite her clear and obvious right to remain in the UK, based on the rules as they are. She was still locked up. And that's unlawful detention as far as I'm concerned, because from the moment she was asked for her status, wasn't able to prove it, she was asked to go in and detained impromptu in such a, I would say, overly aggressive way. The whole point is the United Kingdom has a right to maintain its borders, to maintain and operate an immigration policy, but they've got to be reasonable when doing that. It's got to be done in a just and fair manner. Many people are going to, I would say, suffer this problem. Why? Because, number one, you have people who go to solicitors and legal representatives that are not qualified, and some are unscrupulous. So they pretend to send applications and don't send applications. The longest period we've seen that happen for was a gentleman who came in. He'd been contacting his solicitor for 5 years on his application, and had been given a letter, and that letter was actually for subject access, not for a pending application. So often when we have to break that news to people that there's no application in the Home Office, it's shocking, it's traumatizing. And this man, on calculation, had been in the United Kingdom for 25 years. And so even though he had attempted to make and correct his immigration status, unbeknownst to him, he'd been duped by somebody who pretended to be a lawyer. The lawyer's office had closed, the lawyer was not on the roll, so I couldn't trace the lawyer. So that led that person into shock. Now that gentleman has to find the £1,000+ it will cost to put in his application and his NHS fee. And this is somebody that hasn't been working, that's elderly. So it's another setback. I don't know if he'll be able to afford the cost for a year or 2 years. Even if he wants to apply for a fee waiver, the fee waiver doesn't apply for people who are making applications for settlements. So you see, definitely it's going to take that man some more years. So 20 years, the 5 years, plus however many more years it's going to take him to save for an application. So you can't blame people when they tell you year after year they try to sort their status out, but the cost of living, the cost of having children, the cost of keeping roofs over their head has prevented them from doing so. It's not deliberate. Other times you have people whose parents may have brought them into the country and died, so the documents needed to regularise your status or make the applications to the Home Office are not there. This often happens when people are brought in at a young age by parents who either are British or have settlement. Then when the parent dies, the documentation has not been passed to the children because either the children are considered too young and the person, the carer, responsible for the children doesn't take advice on what to do. So when the caregiver moves on or the child moves on, documents get lost. Then the person moves, transcends into adulthood. So far as they have their NI number, maybe continue working, just doesn't leave the United Kingdom. Year goes, year comes, year goes, year comes. And then before you know it, again, years have passed by, no regularisation of status, quite specific to a particular set from the diaspora, the Caribbean diaspora community. Now, I'm not sure whether that's a specific reflection on cultural barriers that might be specific to that subsection of the diaspora community, but the general reasons are those that I've mentioned: the inability to produce documentation, the fact that sometimes years go by and the evidence that you need when you're making an application, the burden of proof, as we've always said on this program, is on you. So before people move around, it's important that if there's an aunt that knows when parents were around, what your history is, if you don't know because you were so young, that you get those people to write statements, provide information to your lawyers so that they can help you. It's just a very, very unfortunate situation. We do feel that it is very much so particular to the Afro-Caribbean community, because you do have people that are Caucasian from the sub-Saharan Africa, Australia, Canada, that again have ties to the UK, can't always prove their status, but they don't seem to have this, let me say, adverse decisions made against them. But then again, the Home Office can prove from their own statistics how many people are adversely affected in this manner. There are many routes towards British nationality apart from just being born British. So it's important that you do go to somebody who specialises in this area, because when there's gaps in the evidence, again, the standard that should be applied to what you're able to produce has to be laid out. We have challenged the Home Office many times at the High Court and been successful when it comes down to British nationality, because when somebody on paper should be eligible to apply straight away for a British passport and that application is actually rejected, you can then make representations, but if the Passport Office does not accept, you then have to go to the High Court to ask that the decision be reviewed, which is not a simple or cheap exercise. The other point is, if you feel that a person is entitled to British nationality and you are not sure, or there's missing evidence, you can apply for naturalisation. You can and should apply for some discretion to be applied to the consideration of your application, especially if you can prove more than 2 and 3 centuries of being in the United Kingdom. How can you say somebody who's been here for over 30, 40 years should not have a right to stay here? It's a complete breach of their human rights. Complete. And the fact that the Home Office themselves did not keep accurate records going back before the 1990s is often a burden to people, because when you know that your parents have indefinite leave to remain stamped in their passports, but your parents have died, and you write to the Home Office and ask for records, and they say, well, we don't have records. It's a problem.
When you're looking for a solicitor to deal with your case, you don't just look for any solicitor, you look for the right solicitor. An expert who knows what he's doing can deal with your case the right way, achieving the best results. Obaseki Solicitors has more than 100 years of specialist experience serving the local community in immigration law. property law, human rights legislation, civil and criminal litigation, family law, employment law, Sharia law, business law, maritime and commercial law, providing professional legal services globally in Africa, Asia and Europe. Be assured we'll be able to deal with your case the absolute right way with results. So, contact us today by phone on 020 7739 7549 or go online at www.legalpower.com.
If the people or the person concerned has never at any point put in any formal application to the organization,
that's fine. But what if their parents have? What if their parents, who brought them into the country or gave birth to them here before taking them out of the country, made applications to the Home Office, the DWP, HM Revenue? So you can look to other organisations to prove your history or your parents' history, because at times it does go back to the parents, in order to support your applications towards naturalisation under discretionary grounds or for long residence based on the years you've spent here. So making that decision as to whether you're entitled to British nationality is important. If you fail on the test for British nationality, you then think about whether you should go for naturalisation on exceptional grounds. If you can prove centuries of being here, that you're never going to be asked to leave here, then you might try to do it that way. But you must take advice, because the way that the discretion is fettered is very specific. Alternatively, then you try and apply for settlement. Now, once upon a time, when you were here for more than 20 years and you applied for indefinite leave to remain, it was given to you. But now we are finding that many people who've been here for more than 20 years are only being granted 2.5 years limited leave, despite the very extortionate cost of the application. So that means somebody who's already been in a position of weakness, not being able to work for years and not being able to regularise themselves, after 20 years, 25 years in some of the cases I've exampled, would still have to make this exceptional application and be granted 2.5 years, and then make another application and then another one and another one. So again, subjecting to another 10-year regime before being granted indefinite leave to remain. That in itself is also quite harsh and adverse given the history they've already presented. It's a very tough regime, but you've got to get your head around it and you've got to get expert advice so that you're not, let me say, putting yourself further down or making it more difficult for yourself. It's important that if you're in that situation to have a solicitor that creates a case plan for you so that you do achieve the best status possible, because it's definitely not easy.
Let's take a look at people who have not even stayed that long, who have probably stayed like 10 years.
Yes.
And already have children. They've been in the UK for 10 years plus, and they have children that have stayed in the UK for more than 8 years. What are their chances of regularizing themselves?
So again, another one of the main problems is bad advice. Some people go to solicitors, and many of these people who've been in the country for a long time, these cases that we're talking about, they actually went to get representation, but sometimes they were given wrong advice. And as I gave the example of the man whose solicitor pretended to send off an application, some are victims of bad solicitors. But if you're in a situation where you haven't been here for the centuries that I'm talking about, but you've been here for 8 years going towards 9 years and you have children, again, the 7-year rule is not an automatic one. You might have to wait till your eldest child reaches the age of 10 to naturalise. Once the child is naturalised, then you can apply as a parent, as a British child. If the child has been here for more than 10 years, yes, it should be without bar. It should be without bar. But where the parents have very precarious immigration histories, we have seen it being challenged. But that's been within the last 2 years, there have been some challenges to it. But those are situations where parents have very adverse criminal and immigration histories. But you see, the Home Office has to look at the interests of the child when considering such situations. And usually that trumps any bad criminal or immigration history, unless the crimes have been so abhorrent and been subject to the conclusion that the person's presence is not good or conducive for the public good. the UK is very much so against health tourism or people abusing the NHS system. So there has been a very, let me say, a very big no-no towards people who've presented with things like HIV, rare conditions, cancer, etc., even serious strokes and other prevailing situations. The situation and the way that that's looked at is they look at, can this treatment be carried out in your country, even if it's at an expense? They look at the ability of that person to be moved and their ability to fly. So if at the time of assessment of your application you are considered unfit to fly, they may give you a limited period of leave to remain until they consider you fit to fly. So once you make an application for exceptional circumstances, private family life, or whatever you want to present in order to keep you there, because you don't qualify under any other route, you only have your prevailing medical situation. So you're saying, look, outside the rules, look at my case compassionately, blah, blah, blah. Present your medical, your consultant's reports, put that all in. The Home Office may still turn around and say, well, you don't satisfy any of the routes to stay in the country. At the moment, your consultant says you're not fit to fly. So due to that circumstance, we are giving you 6 months leave to remain. So after spending all that money for your application, unless you're in hospital and you can qualify for a fee waiver of some sort, you're only given 6 months. So in 6 months' time, you're going to have to make another application or make a decision to leave. Hence, we always say when a client comes in, or if you're going to see a lawyer, ask for the percentage chance of success of your application. It's so important now that these applications are costing thousands of pounds that you consider if that money is best spent on your application to stay in the country or better spent to help you reintegrate and settle back in the country that you are being sent to. It sounds harsh, but it's a very important reality. We don't want to see people who spend thousands of pounds with applications that are not going to be successful. It's not prayer, it's not anointing oil, it's not, you know, it's actually about basis and actually qualifying for eligibility for under a route to settle. Then, if there are no provisions to treat you, you have specific or like a brain injury either, then you have to present the details. Again, sexual orientation, another route that may have to lead to you making an application based on human rights. If you're from a country where sexual orientation outside a usual heterosexual relationship is illegal, you may have to make a claim for protection and for protection of, first, when I say protection, for asylum, and also under the Human Rights Act. But again, Britain is leaving the EU soon, so we're waiting for the conclusion as to what the British Bill of Rights will contain. Also, another reason why very, very important that you go to a specialist immigration advisor before making that decision. And it's also free. So for many people who we see that they're going to suffer harm, injury, and that's serious harm if they go back to the country, we may advise that they go and make an application for protection at the Home Office. And that can be done directly or through phone call. And if the person involved is underage or vulnerable, that can be spelt out to the Home Office, so special provisions can be put in place.
But there are EU dependents, people who have triggered their
rights to stay.
To stay, depending on EU citizens. What should Britain finally leave the EU, and those ones have their 5 years going to an end, what chances would they be having?
Well, this is one of the reasons why the Brexit negotiations took so long. Theresa May confirmed that those people who have come in during this transitional period, so that's up until 2019, will still acquire the same rights as people who have been here before. So the dependents, so that's, you're not the EU national, you are the dependent relative. So you're married to an EU national, you're the external or close family, immediate family member, or distant family member of the EU national. Well, again, you have your 5 years, and if it's marriage and the relationship has broken down towards the end of the Brexit period, you'll still be able to exercise your entitlement to retained rights of residence. So very important that you gather information that of your EU relatives' work activity and the fact that they were exercising treaty rights during this period and up until the transitional period. And the same applies to the distant family members. You have to show that you are either still dependent on that person, or if you're not still dependent on that person, outline reasons why maybe the relationship is broken down. Sometimes we see children or stepchildren that get thrown out of the house one way or another, or we're human beings, the relationships break down one way or another, even between parent and child. You have to try and retain as much information about your EU sponsors' activities, but it can be difficult. There are rules. There is also guidance to caseworkers on how to treat such cases. So the whole point is get expert advice on it, and also gather as much evidence as you can.
Okay, before we'll round off this program, let's quickly look at those of the Africans in the UK who I'm going to put it, lately we'll find out that there have been criminal attempts on people's lives. In fact, people have been shot, children have their children killed, and it's actually becoming like a virus in the community. Now, what advice would you give to, and it's basically more of an African thing, the black community thing,
gang violence, knife violence is not just subject to one specific community, but at the moment, the prevalence of death, the 46 plus young people who have died only this year, a majority have been from the Afro-Caribbean community, and quite a few specifically Nigerian children. But there have been Congolese children in that mix. There's also been Somali children in that mix, but a good number have been from the Nigerian diaspora community. Number one, I would say it's so important to know where your child is and who they're hanging out with. You know, bad friends are bad friends, and gang members are gang members. And if you're not particular about who your children are hanging out with and what they're doing, then you ought to be. Number two, there's been so much local government cuts on activities for young children, policing, and these services are what keeps our kids focused on the positive. If you don't give a child anything but negative, they're going to go and gravitate towards the negative. So if the child has been excluded from school because they have a challenging behaviour, there's no alternative service for them to go to, they'll go to the school of the streets, and the streets will teach them how to become men of the streets. And that is just a sad thing. Number three, talk. Do not keep quiet when you see things that are at risk to you, to your community, to your child. Do not be scared and intimidated by gang members. They thrive on intimidation. Report to the police. Report to Trident. If you're not getting success, go to a lawyer. A lawyer can make representations. We can make representations for protection. We can make representations on you and your family being moved. We can make representations for injunctions. So seek advice. We're here to help you.
All right, we're here to help you, and that's how far we can go. We've touched on a number of issues on the program. We've looked at long residency in this country and proving that you've been here a long time in order to settle down or for settlement and for British citizenship. If you fall into any of this category, you should get in touch with your solicitor as soon as possible, or get in touch with Citizens Advice Bureau, or better still, you might want to contact us on the program. The number is on the screen. You can call and we'll see how best we can advise you on dealing with some of this. And finally, we also touched on the issue of violent crime in the community. Keep an eye on your children, who they hang out with and where they go. Thank you for being part of the program. Jennifer, thanks for coming on the show today.
My pleasure. Thank you.
Enjoy the rest of your day and keep out of trouble. Bye. Regardless resident status abroad, living outside the shores of one's homeland can really be challenging and sometimes very difficult. Let's be sincere, to keep pace with updates from the host country abroad can really be difficult. Here on Dialogue in Diaspora, we give you every information, every news, every current issue you need to know on happenings outside the UK. Dialogue in Diaspora is your link between the world and the United Kingdom. It's your window to African development. Here, live on Ben Television.